Hello, everyone, and welcome to the webcast. My name is Christine Dorsey Davis. I'm the Executive Director of the Ohio chapter of the American Planning Association, and I am your webcast moderator. Today is Friday, November 3rd, and we will hear new developments in planning case law. Yay! For content questions related to the presentation, go ahead and type those in the Q&A box. And we will normally we get to those at the end all together in the Q&A, but our panelists agreed that answering the questions kind of as we go along and are, dealing with each case might be easier. So again, type your questions in, and we'll pepper those questions in throughout the presentation. If you're having any technical issues, also just type in the Q&A and I'll do my best to help you with those. On your screen is a list of our sponsoring APA chapters and divisions for 2023. Thanks to all those participating sponsors for making these webcasts possible and free to members. Today, we are sponsored by the APA Illinois chapter. So thanks, as always, for joining our webcast series and for hosting today's session. Our last two sessions of 2023 are listed up here on your screen. You can register for these by heading to our website, ohioplanning.org/planningwebcast. And we will be starting the 2024 schedule here within probably 2 weeks. So check back on our website for future sessions. Today's session is worth 1.5 regular CM credits or that coveted 1 law CM credit. And you can log those credits by heading over to planning.org, log into your My APA account. And from there, you can search by today's title or event number, both of which can be found on our website. Again, ohioplanning.org/planningwebcast. If you're on social media, be sure to like us on Facebook. That's where I post any important date or time changes when new sessions are available for you to register for. So be sure to like us so that you get that notification. We record all of our sessions and we post them up onto our YouTube channel. So be sure to subscribe to our channel so that you get notified when new sessions recordings are up and available. And to note, this session today is being registered for on-demand credit as well. So you can get your 1.5 regular CMs or your 1 law CM by viewing this after the live version through December 31st, 2023. So that's the end of my spiel. Again, if you have questions, type them in that Q&A box and we'll be getting to those. And I am going to stop sharing and turn it over to Erin, who is going to kick things off for us today.
Thank you so much, Christine, and welcome to everyone who's joining us today. I'm so glad to be spending the early part of the afternoon with all of you, talking about some recent developments in planning case law. I know I can speak for, Megan and myself, that planning cases and planning updates are some of our favorite things to talk about. And we are coming into the webcast from Chicago and Vernon Hills, Illinois. We work for a law firm called Ancel Glink, which primarily represents local governments in the state of Illinois, including municipalities, park districts, townships, libraries, and all sorts of local government entities. So we're really excited to be joining you here today. And as Christine said, we are open and very excited to hear your questions. So please feel free to utilize the Q&A function and we'll be happy to answer your questions.
Hey, Erin, real quick, can you go up and hit display settings and then swap?
Oh,
I know, us with the multiple monitors. These are the things we have to do. Okay, now it is perfect. Thank you.
So we're going to get started just by introducing ourselves. My name is Erin Monforti, and as I mentioned, I'm an attorney at Ancel Glink, and I primarily work out of our Chicago office. I assist our firm's land use and zoning practice group on a variety of matters. I also work pretty closely with our municipal clients on other corporate and litigation matters, and I work with our park district and library clients. I really enjoy questions involving the First Amendment, other constitutional issues, and of course, land use and planning issues. Megan or Katie, would you like to go ahead?
Sure. Hello, everyone. I'm excited to be with you all today. My name is Katie. I'm with Ancel Glink in the Chicago office. I advise our clients on general corporate matters. I work in our election law group, as well as somewhat related to zoning and land use. I do a lot of real estate work, which is exempting properties, abating accumulated taxes, and looking at property tax appeals that impact our clients' taxes. So excited to speak with you guys today.
Hi, I'm Megan Mack. I'm also an attorney with Ancel Glink, and I've been with the firm about 7 years. I represent a lot of park districts and townships and do a lot of municipal corporate work. I also specialize in land use and planning. And prior to this, I was actually an assistant state's attorney for 10 years. And before that, I was a planner. So I've now kind of married all of the jobs that I've had into one. So excited to give you our brief presentation today. And I will add that even though we are 3 lawyers coming to you from Chicago, that this is not to be, I guess, treated as legal advice. There's our disclaimer note. And if you have questions, please always run things by your own municipal attorney.
Thanks, Megan. And just to set the scene for our presentation this afternoon, we have reviewed and analyzed and put together slides on relevant case law updates from a pretty broad survey of states across the country. As Megan and Katie and I mentioned, we all practice and are licensed in the state of Illinois. So there's a slight skew towards Illinois cases and Seventh Circuit Court of Appeals cases, but we tried our best to expand our kind of scope of review here, and partially in credit to some great publications that are online and resources that I'm sure you all have referenced or used in the past, including the Planning Law Digest and some other great resources for planning law that goes beyond our scope of practice. So, of course, we're again very excited to hear your questions and happy to give you some updates from our corner of the country and, of course, elsewhere. So we're going to get started and dive right into the cases.
Okay, so sign regulations in the framework of the First Amendment and restrictions on speech have been a reoccurring theme lately in the way that the law and planning worlds kind of overlap. In Geft Outdoor LLC versus Monroe County, the Seventh Circuit upheld an Indiana County's billboard variance procedures after Geft Outdoor, a billboard company, challenged the county's sign ordinance for violating the First Amendment. The county required anyone that wanted to build a sign to obtain a permit, with exceptions for government and certain non-commercial signs. Geft actually did not apply for a permit, but they requested from the county a variance because the digital billboard it wanted to erect had off-premises commercial messages, which was not allowed under the county ordinance. After the variance request was denied, Geft actually sued the county, which is why we had the case, and they argued that the sign ordinance had unconstitutional content-based restrictions because they differentiate between commercial and non-commercial signs, as well as that the permit and variance procedures were unconstitutional prior restraints on speech. So prior restraints on speech are highly disfavored. They must be narrow, objective, and definite. They must be narrowly tailored to serve a significant government interest. They must leave open alternative avenues for speech, and they also must not put too much discretion in the hands of government officials. So in this case, Geft is obviously arguing that the government officials deciding whether or not to grant the variance have too much discretion in that decision. So at the trial court level, they issued an injunction preventing the county from enforcing certain provisions of the ordinance, including the permit and variance process. The trial court also upheld the remaining content neutral regulations of the ordinance. And just as kind of a refresher, a content neutral law or regulation that applies to expression and speech without regard to the substance of the speech, whereas a content-based law or regulation does discriminate based on the speech that's being conveyed. So that's the difference between those sorts of regulations. The county did repeal content-based regulations from their ordinance, including its ban of off-premises commercial speech. But they appealed to the Seventh Circuit Court of Appeals, asking the court to restore its variance procedure. On appeal, Geft argued that the county's discretion whether or not to grant a variance is so broad that it's a prior restraint on speech. In other words, Geft is arguing that no one is allowed to speak by putting up the billboard until they apply for and receive the variance. So they're kept from speaking until that occurs. The Seventh Circuit agreed that the variance procedure was a prior restraint, but then the question is it an unconstitutional prior restraint? The Seventh Circuit held that it was not unconstitutional. They pointed to the fact that the county removed all content-based sign regulations, so any constitutional concerns regarding the ordinance must be about discretion rather than outright censorship. The court also found that the county permits ample alternatives for speech. Geft could erect a non-digital billboard within the required size, height, and setback limitations, but they chose to apply for the variance for a digital billboard. Third, the court found that a variance is only required when someone wants to install a sign that violates a substantive standard. And finally, what I found most interesting of the court's findings was the court stated that there is little need for a federal court to intrude on municipal land use regulations where the state legislature requires local governments to have the variance provision in their zoning codes and provide an opportunity for judicial review. So essentially the court was saying it's not essentially their place to step in when the state law is providing for that. The Seventh Circuit vacated the injunction against the county's variance procedures and sent the case back to the lower court for further proceedings. And the significance of this case, to kind of sum it up, is essentially that local governments can use content-neutral variance procedures, even if that means that government officials will have discretion in deciding whether or not to grant them.
All right, so we're going to move on, and like I said, this is a broad survey, and it'll range in many different topics, question or case to case. So, in taking kind of a left turn, we're going to talk a little bit about cannabis dispensary permitting and zoning. So in Green Genie versus the City of Detroit, the Sixth Circuit upheld the city's denial of a permit application to operate a medical marijuana dispensary. The city denied the request because the proposed dispensary would fall within the city's drug-free zone. So the city had in its city code created drug-free zones that prohibited cannabis facilities within 1,000 radial feet, so 1,000 foot buffer around the dispensary, and they could not be located within 1,000 feet of the zoning lots of schools and other sensitive uses. The operator sued once their permit was denied and argued that the city's decision violated due process and equal protection rights because, among other things, the city previously allowed similar facilities within the drug-free zone. And their federal court claim was based on a theory of equal protection. And specifically, Green Genie, the dispensary, argued that there was an intentionally different treatment of their dispensary vis-a-vis other facilities that were similarly situated. The federal district court dismissed the case, and it was appealed to the Sixth Circuit Court of Appeals. The Sixth Circuit rejected the operator's argument that the two identified facilities they cited were similarly situated under the equal protection analysis. The court found no evidence suggesting that the operator was intentionally treated differently than other dispensaries which may have been granted permits. And the Sixth Circuit further noted that there were other facilities that had been denied permits for similar reasons that the city denied the operator's permit. So under the equal protection analysis, the court essentially found that Green Genie was not an outlier. It wasn't treated so differently, and they found no evidence it was intentionally treated differently for discriminatory reasons when compared to similar applications and situations in the past.
Okay, moving forward to another new topic on annexation agreements. This is an Illinois Supreme Court case, Village of Kirkland versus Kirkland Properties. In this case, the Village of Kirkland sued a real estate developer seeking to enforce the terms of an annexation agreement against the real estate developer as a successive owner. The original annexation agreement incorporated 115 acres of land to develop residential properties. During the development phase, a second real estate developer bought a portion of the original land that was subject to that annexation agreement. The village then sued the real estate developer to enforce that annexation agreement's development terms. The appellate court held that the agreement bound the developer and applied to all successors in interest owning portions of the original property that were subject to the annexation agreement. And it's a pretty straightforward case. The decision went up to the Supreme Court of Illinois, who affirmed it.
Okay, this is another speech-related case, one I found very, very interesting. It's from the Ninth Circuit Court of Appeals. And through this case, we can see how cities can't regulate landlord and tenant relationships as a means to promote fair housing. So in 2017, Seattle enacted the Seattle's Fair Chance Housing Ordinance. It prohibited landlords from inquiring into the criminal history of current or potential tenants and taking adverse action against them based on that information. Adverse action meaning denying their application or evicting them. Affected landlords and a landlord trade association sued the city, alleging violations of their federal and state rights of free speech and substantive due process, essentially stating that the government is interfering with their fundamental rights. So the district court denied the landlord's challenge to the ordinance, ruling that their First Amendment rights to free speech and substantive due process were not violated. On appeal, the Ninth Circuit ruled that the ordinance did violate the landlord's free speech rights, but did not violate their substantive due process rights. Relating to the ordinance violating their free speech, the court determined that the ordinance was not narrowly drawn to achieve the city's goals, and that there were narrower alternatives that would accomplish those same goals of increasing fair housing without intruding as much on the landlord's First Amendment rights. The Ninth Circuit determined that the complete ban on any discussion of criminal history between landlords and tenants was not in proportion to the interests served by the ordinance and reducing barriers to housing. The court also noted that other cities have enacted similar ordinances with the same goals as Seattle, but those ordinances imposed a lower burden on landlord speech. Example is San Francisco, Washington, D.C., and Portland, and those have not been struck down. So in comparison to the Seattle ordinance, which just completely banned any discussion of criminal history, I thought it'd be interesting to see what the San Francisco ordinance does differently and why that hasn't been struck down. So, and the San Francisco ordinance is pretty lengthy, so I'm summarizing, keep in mind. But essentially what the ordinance does is it prohibits housing providers of affordable housing from inquiring or requiring disclosure from applicants for affordable housing related to any information about an arrest not leading to a conviction, an expunged conviction, a conviction more than 7 years old, or a conviction arising out of conduct that has since been decriminalized. So those sort of convictions can never be discussed, essentially. But under the ordinance, the housing provider can require disclosure of conviction history and inquire into it once they have determined two things: that the applicant is legally eligible to rent the housing unit, and that the applicant is qualified to rent the housing unit with their rental and credit history. So once the provider determines that they're eligible in those two fronts, they then can inquire into the criminal history. But it's sort of, from my perspective, hoping to get people's foot in the door before they're completely shut out of housing based on their criminal history. And then what I also found interesting, the San Francisco ordinance actually regulates what the housing provider can consider in determining whether or not to provide the affordable housing. So they can only consider directly related convictions. And what that means is the conduct for which the person was convicted. Sorry, let me just find my spot here. Sorry. Yes, so a directly related conviction means the conviction has a direct and specific negative bearing on the safety of persons or property given the nature of the housing. So sort of a subset of conviction history that housing providers can consider. But when you compare the Seattle ordinance to the San Francisco ordinance, the Seattle ordinance was just a complete blanket almost, banning any discussion of criminal history, whereas the San Francisco ordinance has more detailed regulations. It's not just a complete ban. So that's something to keep in mind, is a ban on the content of speech will likely be struck down if challenged.
Thanks, Katie. And we have a question in the chat. That's a general, very useful, I think, question as we go through these cases from different jurisdictions. I would like to hear more about how legal opinions from various court levels affect parties from different areas of the country or levels of government. For instance, is a U.S. Supreme Court decision the only level that applies to jurisdictions across multiple states? So in this presentation, I'll just take this for example. We have cases that are both federal level and state level, and we've tried to delineate that right under the case name on each slide. So taking Yim versus City of Seattle, it was issued by the Ninth Circuit Court of Appeals. The Supreme Court, the U.S. Supreme Court, is the only court whose opinions are binding nationwide. Then you go down a level in the federal court system and you have all of the circuit courts, of which there are 13, I believe, between 11 and 13. And so the Ninth Circuit Court of Appeals includes California, Oregon, Washington, and maybe a couple other states. We practice in the Seventh Circuit Court of Appeals, which is Indiana, Illinois, and Wisconsin. But then if you go down even one level lower, each state has federal district courts which act as trial courts. So if your case goes to trial or is heard at the initial level and then it's appealed to a circuit court of appeals, then the circuit court of appeals decisions are binding on the states within the circuit. When you see on the slides that the case was issued by a state level court, which maybe Katie, Megan, and I can make a note to point out going forward. For example, a case out of the Illinois Supreme Court is only binding on courts in Illinois that are at or below that level. Sometimes you'll see in case law that courts borrow analysis or reasoning from cases that were issued by neighboring states or other states, and that usually happens when there's a novel issue of law being addressed. So, for example, a state like California, which has kind of been on the forefront of affordable housing legislation, they've heard many more cases on affordable housing laws than courts in even Illinois have, and we do have an affordable housing statute in Illinois. So that's a brief rundown on jurisdictions and how the court system works. We also have another comment, just thanking Katie for explaining the narrowness of the Yim versus Seattle decision, because it's always interesting when you can compare your comparative analysis of the Seattle and San Francisco zoning ordinances and the fair housing ordinances is really interesting. Okay, so we're still kind of in the free speech First Amendment realm with Shurtleff versus City of Boston, and this is a U.S. Supreme Court case. So again, the highest court in the country issued this decision, I believe, sometime early this year. So the U.S. Supreme Court recently found the City of Boston violated the First Amendment by denying a religious group's request to fly a Christian flag on a city hall flagpole. Boston had a long-standing practice of allowing citizen groups to fly flags from a city flagpole of their choosing, but the city had denied the request to fly a Christian flag, believing that flying a religious flag on city property would violate the Establishment Clause. So the Establishment Clause is the portion of the First Amendment which provides that governments shall not establish or respect any one religion. The court looked at 3 factors to determine whether the speech was government speech or private expression. So the first factor being that they assessed the history of flag flying at City Hall. They assessed whether the public would tend to view the speech. And it's kind of an interesting side note on this case that flying a flag is considered expression that could be protected by the First Amendment, and whether that speech would be city speech or private expression. And the third factor in this case, which ended up being determinative, was that the extent to which the city controlled the flag raisings and was historically shaped the messages that were flown from the flagpole. So the court determined that because the city allowed citizens and groups to fly flags from the flagpole, the flagpole was transformed into a public forum and was not government speech. So denying the Christian flag based on its message was a violation of First Amendment rights. So the city had never ever denied a request to fly a flag before the Christian flag was proposed, and in that way, it was a public forum for private speech rather than government speech. So a quick note on government speech, it's kind of an interesting issue, especially for many of our clients who are grappling with issues about whether or not to post posters supporting a certain issue, or what kind of expression the government can actually engage in. So government can't be compelled to endorse or deny a particular viewpoint, but can choose to speak without content neutrality. So while in traditional First Amendment cases involve the restriction of private person's speech, the government is allowed to speak as it chooses without being held to the stringent standards of content neutrality. An interesting case that might give a little better context: in 2015, the Supreme Court issued its opinion in Walker versus the Texas Division of the Sons of the Confederate Veterans. In that case, an organization sought to issue license plates with Confederate flags in Texas, and the state denied their application to place flags on license plates. And the court determined that that denial was appropriate because license plates are considered government speech and not private speech. So the government wasn't discriminating based on the message, it was just controlling its own speech, which they determined the license plates to be. Looks like we have another question. Would this decision cover city websites or TVS in city hall lobbies? So it's a very fact-intensive analysis. If they are, if they're allowing private individuals to post without much regulation or any kind of limits on the speech, I would say it's turned into a public forum, similar to the shirt left case. However, if the government is really tailoring the messages on a city website, and social media is a whole other ballgame. We could talk an hour and a half just on social media and government, but it all kind of depends on the facts and how much control the government has over the speech that's being expressed.
Aaron, I was going to add that it's government speech when it's controlled by the city on the websites or on maybe the city's Facebook site. But as soon as you get into those chat features where anyone can post anything, then you're in First Amendment world, and that doesn't have the same protections. And so you can't, as the government, start removing posts that you don't like, which is a very broad way of explaining a seminar that could be at least an hour or two.
Absolutely. Thanks, Megan.
There was a new question that just came in that says, can an agency eliminate the public forum by prohibiting everyone from posting flags? And it's not necessarily a public forum just because the government uses the flagpole. If the government continues to regulate the flagpole, then it's still considered government speech. It's when the government stops regulating it or allows someone to put up a flag and doesn't make them take it down, that it then becomes a public forum. But certainly a position that a government could take was that they didn't allow any flags to fly. I don't know if you guys want to weigh in on that.
Yeah, that's kind of interesting. The use of the word forum, it's such an unnatural word. That's how you know it's legalese. It's lawyer jargon. In a lot of Supreme Court cases, one of the key questions that's asked on First Amendment issues is what kind of forum was the speech expressed in. So there are traditional public forums, designated public forums, limited public forums, and non-public forums. So there's a whole spectrum of First Amendment analysis there. One thing I'll add to Megan's, and I agree with everything she said, is that there are some places where restricting speech outright is not an option. So traditional public forums like sidewalks, like public parks, that would not be a great strategy. But like Megan said, in limited or designated public forums where the speech is more narrowly tailored to a specific purpose, or where the government has only opened it for a limited time or for a limited purpose, in some cases, prohibiting any expression is a permissible regulation. Thank you for your thoughtful questions. Oh, and here's a picture of the flagpoles. So this is Boston City Hall, and on the left, we've got the American flag and the POW MIA flag. In the middle, I'm guessing that's either the, it shows what I know, the Massachusetts or City of Boston flag. And then I saw another photo of this with a different organizational flag as well. So this third flagpole is the one that had been traditionally open to groups to use.
Okay, so switching to some zoning and federal regulation law. This is the Trinity Sober Living versus the Village of Hinsdale case. Hinsdale is a municipality outside of Chicago. It's to the west side. However, this is, as one of the questions earlier, this is a Northern District case, so it has broader implications than just two people within the state of Illinois. So although I should note that the decision in here actually relates more to a motion to dismiss, and in the end, the party settled. So I guess you have to take that into account as well. So Trinity Sober Living was a drug and alcohol recovery treatment center, and the Village of Hinsdale had enacted some local zoning that prohibited anything with single-family residential neighborhoods under their zoning code. So the center and the Department of Justice sued the Village of Hinsdale, alleging violations of the Fair Housing Act and the Americans with Disability Act. The FHA and the ADA discrimination claims resulted from the village's efforts to prevent the operation of a sober treatment facility in a single-family residential neighborhood under the village's zoning code. What Trinity Sober Living was seeking to do was to operate a 5-bedroom home for the recovery of 10 adults in what they chose to be a great location because it was a block from their office. The Village of Hinsdale filed a motion to dismiss that was denied, and then the parties did settle this case. Under the settlement, the village agreed that it needed to amend its zoning code to comply with federal anti-discrimination laws. That includes permitting homes for persons with disabilities in residential districts. And the village also had to pay $790,000 in monetary damages to Trinity Sober Living, and then a civil penalty of $10,000 to the United States. Oh, I see the question in the chat. Oh, thank you. Actually, someone said Trinity wasn't a treatment center, it was a sober living home. Treatment was provided offsite. This is an important distinction. You're right. Thank you very much. And Hinsdale has not brought its zoning code into compliance with the Fair Housing Act. Interesting. I wasn't aware of that. We don't represent them. But thank you for the distinguishment and checking me on that fact. I appreciate that. There's a question on here, Aaron, that had to do with going back to the public speech. Would local election campaign at public park would be termed as government speech?
I don't think so.
I don't know.
Yeah, I would say that a public park, again, is a traditional public forum. Obviously, if the government is hosting its own event, then it could be government speech. But when I see local election campaign, I'm thinking it's an individual candidate who's hosting something in the park. So even though the park is a public space that's either owned by a municipality or operated by a park district, any private speech that's takes place in that park is protected. And then briefly, there was another question that I started to answer by typing, but I'm too slow. If a government allows the community to post flyers on a city-owned bulletin board, could they run into the flagpole issue if a controversial poster was removed? Yes, they definitely could. So if they've opened it to the public as a public forum, meaning that you can traditionally post, you can walk into City Hall and put a tack in a poster and leave it on the bulletin board. If they remove a controversial poster, it could be a First Amendment violation. There are very few areas of speech that are not protected by the First Amendment. Obscenity, fighting words, anything that inspires violence. Those are things that are not protected. But things like profanity, some of the other speech that might make us uncomfortable or we wouldn't like to see that in our City Hall, there are really specific analyses for those. So content neutrality is kind of the catch-all way to avoid those kinds of violations.
I think maybe I can try and respond to some of these so that we don't get too behind on time. There's a bunch of questions related to the Trinity Silver Living case.
Yeah, Megan.
If you just want to move ahead and I'll respond to them in the chat.
Okay, thank you.
Okay. So we are going to switch back to free speech, and in comparison to the City of Boston Bull case, where the court determined it was a public forum, this is sort of a shift into let me make sure I'm using the right phrase, a limited public forum and how those regulations can differ. So in Tyler versus City of Kingston, the Second Circuit Court of Appeals affirmed the dismissal of a case brought by protesters against the City of Kingston after the City Council banned the use of signs and posters in the council's chambers. The plaintiff group included local political activists who wished to display signs and posters as a form of silent speech during council meetings. The council banned the use of signs and posters just days before a contentious meeting at which the public body was considering the purchase of an armored vehicle for its emergency service providers. The political activists sued the city in federal district court, asserting that the prohibition on signs and posters violated the First Amendment. This was dismissed on the district court level, and it was affirmed by the Second Circuit. The court determined that the council's chambers constituted a limited public forum, and in such, a government is allowed to regulate speech in a viewpoint neutral manner, as well as in a reasonable manner. Viewpoint neutral is similar to what we discussed earlier. It's where you're not discriminating based on the actual message or the substance of the speech being conveyed. So the court determined that since the restriction on posters and signs regulated only the form of the speech and not the content of the speech, it was viewpoint neutral. The court further determined that the regulation was reasonable. The council's rationale was to maintain decorum and prevent disruptive activity during meetings. And the court stated that political activists still have a fair and alternative means to express their views, as they were still allowed to speak at the public meeting and they could still display those signs outside the city hall. So essentially, it was a small subsect. While in council chambers, no signs or posters may be used. So the court determined that it was viewpoint neutral and it was reasonable regulation, so it was held up by the court. And that's sort of a distinction between the Boston case, as I said previously, where there's a lot less regulations that they can make in a public forum. And you can kind of get into, are you discriminating against the different applicants? So.
All right. Another really popular topic that we've seen a few cases come down nationwide regarding is short-term rental regulations. So this is, there are a lot of cases that address the same issues as this Hignell Stark versus City of New Orleans. But I think this was the first case that we saw where an STR regulation was struck down as unconstitutional. So in 2017, New Orleans created a licensing regime for short-term rental uses that allowed property owners to apply for a license to rent their property for a period shorter than 30 days. The initial city code provisions made clear that an STR license was a privilege and not a right, and that the city enjoyed broad discretion to issue or withhold licenses. After receiving complaints from neighbors that short-term rentals were creating nuisances in their neighborhoods and increasing housing costs, the city revised its licensing program in 2019. These changes restricted STR licenses to the owner's primary residence. So you could only operate a short-term rental in a residence that is your primary residence. The new ordinances also place substantial limitations on advertising short-term rentals. So a group of property owners challenged the new licensing scheme as unconstitutional under 3 different theories. So the first was that the failure to renew their STR licenses was an impermissible taking of their property under the Fifth Amendment without just compensation. And we're going to talk a lot about takings later in the presentation. The second theory was that the residency requirement violated the Dormant Commerce Clause of the Constitution. And the third was that the advertising restrictions violated the First Amendment. The case made its way to the Fifth Circuit, which has appellate jurisdiction over Louisiana and a few of the other states in the southeasterly region of the United States. And the court found in favor of the city on the owner's takings claim under the Fifth Amendment. The court said that the city had made clear that STR licenses are not a property right. And the city's refusal to renew a license did not violate any sort of right that's recognizable under the Constitution. Second, and most interestingly, the Fifth Circuit ruled in favor of the property owners on their Dormant Commerce Clause claim. Try to say that 5 times fast. Under the Dormant Commerce Clause, states and local governments may not discriminate against or impose undue burdens on interstate commerce. The court held that the residency requirement for STR licenses was discriminatory on its face because out-of-state property owners without a primary residence in the city were forbidden from participating in the STR market in residential areas in New Orleans. The city failed to show that the residency restriction was the only policy alternative for promoting its interests in reducing nuisances and promoting affordable housing. Therefore, the city had failed to show that the discriminatory residential requirement was constitutional. And then lastly, the court found it had no authority to decide the First Amendment claim and just sent the case back down to the district court to determine that First Amendment claim. So this is an interesting case. The Dormant Commerce Clause theory is something that we as attorneys don't see very often. Being in Chicago, I've seen a few cases about the Chicago short-term rental ordinances that had to do more with, again, the takings analysis and whether or not the city had overstepped its home rule authority to regulate short-term rentals in a certain way. But I've seen some traction with this Dormant Commerce Clause analysis. That's pretty interesting. And we've got a comment, and this is a good reminder. Again, this is a case from the Fifth Circuit Court of Appeals, and depending on the leanings of each circuit, there's no guarantee that any trend or any one analysis is going to catch on in other circuits. But that's a good point too, because if the Fifth Circuit has determined the ordinance unconstitutional and another circuit determines that similar provisions are constitutional, and a lot of short-term rental ordinances require that the residence be the primary residence of the person who's renting it out, eventually this could be taken up to the Supreme Court if there's a circuit split, if different parts of the country and different court systems are ruling on these issues differently. So we'll have to see if this comes to bear at a higher level.
I was just going to mention too, there was a question in the chat if we could make these materials available, and we're happy to do that. And we'll coordinate that afterwards with Christine. The next case has to do with municipal privileges. This is a case that is specific to Illinois. And it's, I'll give you a little bit of the background. The Ferraris are property owners. Glen Carbon, it must be a community somewhere within the 5th District. I'm not familiar with it. They own 400 acres of land. 4 acres of land. That's a big difference. They were contacted by the village, letting them know that they had exceeded the local grass ordinance, which I believe, I'm not sure entirely how many inches they were allowed to go to, but they were over it. And actually, Mr. Ferrari contacted the village and said that his lawnmower was broken, and so could he have more time? And the village agreed to give them more time to cut their grass. However, before the extension of that period happened, the village went in and cut the grass anyway, or hired a commercial mower to do so. In doing so, the mower, the individual who was driving the mower struck and damaged Mrs. Ferrari's vehicle. So we have 3 cases that actually come out of this one fact scenario, and in 3 related opinions, the Illinois Appellate Court upheld decisions related to the small property damages claim, alleging that they were caused by property maintenance activities by the village of Glen Carbon and their related entities. The first case, the public mower that killed the property owners, I believe it's their rose bushes. The trial court concluded that the common law doctrine of privilege and implied consent allowed the village to mow along a public roadway without earning a suit for trespass if there is some incidental encroachment. In the second case, the village parked heavy equipment in the yard of the property owner and damaged the property. The trial court concluded that the village had privilege to enter onto the owner's property to make that repair, but not to have a continued presence of the equipment on the property after the repair was complete. They did reward the plaintiffs here with nominal damages, but it wasn't much. In the third case, the village damaged the property's owner's car while mowing the lawn. The court did award compensatory damages for the car, but did not order the removal of the village's lien on the property, as it was related to the village's unpaid mowing expenses. So on appeal, the property owners argued that the trial court did not allow them. They tried to allege that there were improper and ex parte communications between the village's witnesses in the trial court, as well as ex parte communications between the state's attorney who prosecuted this and the judge. But these appeals were all denied because the property owner only presented an incomplete record to the trial, and it didn't support either of these claims. So lots of good findings in favor of the municipality here. Oh, thank you. Glen Carbon is in Madison County near St. Louis, and their maximum grass height is 8 inches. Thank you for all of you who are giving us great feedback.
Okay, so this is a case coming out of California, the California Court of Appeals 5th District, and it is Martinez versus the city of Clovis. So the case has a very long procedural and factual history, but just a little bit of background. The city had historically struggled to meet the California housing community and development standards for affordable housing. In one instance, the city's housing plans were certified based on the city's representation that it would rezone portions of the city to accommodate affordable housing. But the city actually never made the changes it promised. So the state agency repealed its certification of the city's housing plans. In response to this, the city ended up creating an overlay district, which covered the city to allow high-density multifamily housing. That was essentially their attempt to rectify their issues with affordable housing. And this plan was actually approved by the state, but an individual sued under the state of California's housing element law. She claimed that the city's proposed overlay to allow for affordable housing violated the city's duty to affirmatively further fair housing. When the case reached the appellate court, the court recognized that the relevant state laws go further in prohibiting discrimination. They actually require action and administration of programs in a matter to affirmatively promote fair housing. So the court determined that the city's violation of the housing element law was evidence that it had failed to provide affirmative support for fair, affordable housing. And what I really found interesting in this case is that the court had no deference at all to the state decision. The state actually had approved the city's housing plans, but once an individual sued, the court stepped in and said, essentially, that's great that the state certified it. We disagree. they didn't take the affirmative steps. They need action and administration of program, and they did neither. So this was an interesting case where it didn't really matter what the state said. The court had the final say.
Yeah, I just want to jump in and kind of going back to the sort of sub-theme of this presentation, because it is a survey of law. As I mentioned earlier, the state of California has some of the most robust and progressive affordable housing laws in the country. So the application of this elsewhere is not particularly broad. There are presentation materials available through Ancel Glink if you're interested on a survey of affordable housing legislation and efforts across the country, with examples from Oregon, Minnesota, California, and then also I believe we touched on Utah and some other states. So there are materials available on Ancel Glink's Quorum Forum podcast that might be interesting for all of you who are interested in learning more about affordable housing and some of the nationwide trends in that area of planning law. And so quickly, we're going to go through the city of Almont versus Fritsch. Again, this is an Illinois appellate case. Homeowners extended their backyard privacy fence onto a city's public utility easement. I guess onto is an interesting preposition. I imagine that it was an underlying gas line or something like that. The city issued an abatement notice, and the homeowners requested to keep the fence as a reasonable accommodation for their child with disabilities. So their child had a developmental disability, and would frequently flee their backyard. So they wanted to put a privacy fence in to ensure his safety. The city offered an alternative accommodation, which the homeowners rejected, and the city later issued a citation for violating their zoning code, and the homeowners sued. So the trial court ruled in favor of the city and found that the city did not selectively enforce the ordinance as the owners had claimed. They had claimed that it was a violation of the Fair Housing Amendments Act and the Americans with Disabilities Act for the city to issue the citation as they did. The court also found that the city had offered a reasonable alternative accommodation for the child, and the appellate court determined that there was no evidence of discrimination for the selective prosecution claim. So they hadn't just decided to issue a citation based on the family or the child's status as a person with disabilities. The court also found that the homeowners were not entitled to a reasonable accommodation because they failed to provide the city with a meaningful opportunity to assess the requested accommodation before constructing the fence. So traditionally, the reasonable accommodation procedure, if in the employment context, for example, if an employee comes to you and requests a reasonable accommodation, you can then engage in the interactive process. But in this case, the city really had no opportunity before the fence was constructed to engage in that process. The court noted that individuals are not entitled to municipal code waivers when the requested waiver amounts to a fundamental and unreasonable change of the code. So building structures on utility easements was explicitly prohibited in the code. It wasn't as if there were built-in exceptions or other considerations for such construction activity.
And then do we just want to touch on this note really quickly before Megan goes? Someone just sent, and this is a good note, it's important to remember that every jurisdiction that accepts federal funds, especially community development block grant funds, has a legal obligation to affirmatively further fair housing. And it depends on the president's administration, this comment says, whether or not they affirmatively are furthering fair housing. So that is important to note too. So thank you for that.
This is a case that has to do with leases and maintenance obligations that's out of the state of New York that went to the New York Supreme Court. The administrative code in New York City states that the duty of an owner of real property abutting any sidewalk to maintain that sidewalk in a reasonably safe condition. However, after a pedestrian was injured on a New York sidewalk that was adjacent to a Starbucks, the property owner sought compensation from Starbucks, who was the tenant, for failing to maintain the sidewalk under the lease. While Starbucks under the lease was required to maintain the premises, at least it was not required to maintain or make repairs to the sidewalk. Furthermore, the court determined that the city code did not allow shifting liability from the property owner to a tenant for injuries caused by a defective sidewalk. Instead, the legal duty to maintain the sidewalk in a safe condition was by law assigned to the property owner and could not be shifted onto a tenant. So Starbucks was successful here when they made a motion for summary judgment to have the case against it dismissed.
Okay, this case is coming out of the Oregon Court of Appeals, Friends of Yamhill, and I hope I'm pronouncing that right, Yamhill County versus Yamhill County. And in this case, the county permitted home occupations only in buildings that could be classified as dwellings. And what brought this case about was the county approved a conditional use permit for a company to operate a bed and breakfast as a home occupation. But the issue was that was to be operated in a building that was going to be built on land exclusively zoned for agricultural uses. In the farming zone, the only permissible residential use was primary or accessory dwellings and other buildings, this is kind of the magic language, customarily provided in conjunction with farm use. An organization sued the county after the conditional use permit was issued, arguing that the bed and breakfast was not a home occupation that could lawfully be located in the zoning district, the farming zone. The court analyzed the county's zoning ordinance and determined that the B&B was not a dwelling, even though it was possible the building could be used as a dwelling. The bed and breakfast was not dedicated to housing a farm family, but was built for lodging and tourism. So it did not qualify as a permitted structure in the farm district. Because a home occupation under the county zoning code must be carried out in a dwelling, the proposed use of the bed and breakfast was found by the court to violate the zoning code.
Okay, so beach protection and takings, in Chicago today, it's, I don't know, maybe 50 degrees. So when I think about some of these cases that come from our warmer neighbor states, I get a little envious, but I digress. So Bradens Folly is the plaintiff in this case, and they are property owners who owned two small contiguous developed coastal properties in the city of Folly Beach. The city had adopted a merger ordinance that required certain contiguous properties under common ownership, such as the two that Bradens Folly owned, to be merged into a single larger property along the coastline, because the Folly Beach coastline was distinctly fragile and there was worsening erosion in the area. Existing homes on each of the properties were not affected, but the property owner claimed that the merger ordinance interfered with their investment-backed expectations, constituting a taking, because the property owner had planned to sell one of the two properties that were next door to one another. So they argued that that was a taking because they could not do what they planned to do with the property. The court applied the default takings rule from the U.S. Supreme Court's 1970s era decision in the Penn Central case. The Penn Central rule is a balancing test for regulatory takings, which constitute a partial taking of property. So the factors that the court analyzed in determining whether or not this was a taking were, first, the economic impact of the regulation on the property owner. Second, the extent to which the regulation interfered with distinct investment-backed expectations. And third, the character of the governmental action. That is, whether or not the property was taken for a government purpose. So some factual background on this, just because I think it's kind of interesting. An appraisal report commissioned by the property owner found that the ordinance did create a 23% decline in the property as a lot in terms of a loss of profit because it could not sell one of the parcels separately. The Supreme Court, however, has uniformly held that the diminution in property value standing alone cannot establish a taking under the Supreme Court takings analysis for the Fifth Amendment. Here, the reduction in value was far less than other reductions that the Supreme Court has held constitutional. Bradens Folly could rent the houses on the two lots separately and continue to earn revenue, but it refused to accept an offer to buy the two properties at its full asking price. So there was very little flexibility in terms of what they were claiming their investment-backed expectations were, and the court found it determinative that there were other economically viable uses of the property. The court then considered whether their investment-backed expectations were unreasonably violated. So it held that while their expectations were clearly stated, they were diminished because their primary expectation for several decades had not been to sell the lots, actually, but they had used the lots for family vacations and as rental properties, and had delayed their sale of the property. So their claim that they had always wanted to sell the property, that was their expectation to use the property, the court found slightly disingenuous. The court concluded that the city adopted the merger ordinance and other beach regulations with an eye towards preserving the beach from erosion. Sorry, I'm losing my place here. And they found that was a responsible land use policy that was generally applicable and widely accepted nationwide, based on the public costs of super beachfront development. So the court found that there was a proper government purpose for the regulation. And all in all, after weighing all of those factors, they determined that the city did not execute a taking when it merged the two properties under the ordinance, and therefore the property owner was not entitled to any sort of just compensation.
This is a case that has to do with tort immunity. It's another Illinois appellate court case out of the 4th District. Genie LLC was the applicant and then eventually given a cannabis license from the state of Illinois. However, it was working on a lease with a landlord within the city of Galena, and city officials declined to sign a local zoning form that the dispensary needed in order to obtain its state cannabis license. After which then Genie then sued the city. This dispensary had previously applied for a special use permit, but that permit was contingent on receiving its license from the state of Illinois. This was a lengthy process because it occurred really within the span of COVID and delaying a lot of planning and zoning meetings, as well as the state had huge delays in issuing licenses. The license the state did give another cannabis dispensary license to another dispensary within 1,500 feet of the plaintiff. Illinois does not allow, and Galena as well, does not allow for two cannabis dispensaries to be located within 1,500 feet of each other. The landlord thought that in suing the city, he could claim that the city's negligent failure to complete the local zoning form deprived the landlord of the lease's financial benefits. However, the appellate court found that Tort Immunity Act precludes the city from being found liable for its refusal to sign the zoning form. That's an important decision for zoning officials.
Okay, this is a case coming out of the 7th Circuit Court of Appeals. It has to do with the public trust doctrine, which, being from Michigan with the Great Lakes, this is something I learned pretty young growing up, not even intentionally, just where can we walk, what's public land, what's private land, it's hard to tell. But for those of you who don't know, or you may all, the public trust doctrine is a legal principle establishing that certain natural resources should be preserved for public use, enjoyment, and benefit. So in the present case I'm going to be discussing, in the late 1930s, Milwaukee County built a dam on the Milwaukee River in an urban green space called Estabrook Park. In 2017, the county transferred the dam to the Milwaukee Metropolitan Sewerage District for the purpose of removing the dam. After the dam was removed, the water level immediately upstream fell by about 4 feet. A homeowner along the river sued the district, the sewerage district, and the county, claiming that the removal of the dam constituted a Fifth Amendment taking of his riparian rights. Riparian rights are for someone who owns land, a navigable waterway, which in this case was the river. And the homeowner was essentially claiming that the district and county essentially took they essentially took the previous surface water level. So by it falling 4 feet, the 4 feet difference was a taking. So on appeal, the Seventh Circuit upheld the ruling in favor of the district and the county. The court noted that in order to prevail on a federal takings claim, the homeowner had to show that the government had taken, either physically or by unduly burdensome regulation, private property owned by the homeowner. And this is kind of, I think, what is most interesting or helpful coming out of that case, was the court stated that although the homeowner was a riparian owner, and they do have riparian rights as being someone who owns land near a waterway, that those homeowners' riparian rights are subordinate to and encumbered by the state's interest and authority to regulate and maintain its rivers and lakes for the benefit of the public, which is, like I said in the beginning, the public trust doctrine. So this is the court essentially stating the state's rights and interest will always be before the riparian owners. So there's an interesting case having to do with water levels.
Next, we're going to discuss a little bit of historic property and some of the movements regarding statues and other monuments. So in this case, the United Daughters of the Confederacy of North Carolina versus the city of Winston-Salem, the trial court dismissed the United Daughters of the Confederacy's complaint for an injunction. They wanted to prevent the city from removing a Confederate statue on property adjacent to a former courthouse that is now privately owned and that was converted to a residential use. So in 2017, out of concerns related to protests and an incident in Charlottesville, Virginia, the city asked the owner to remove the monument to a secure location over the organization, which I'll call UDC, their objection. So in 2018, the city asked UDC to remove the monument, causing UDC to file a lawsuit for an order to prevent the city from taking any action with respect to the monument pending an adjudication of rights. So they asked for a preliminary injunction, which preserves the status quo until the merits of the case can be determined. The trial court granted the city's motion to dismiss because UDC lacked standing to bring the lawsuit. So in order to bring a lawsuit, you have to be of a certain status with regard to the controversy that you're claiming. UDC did not allege that it owned or had any sort of ownership or legal interest in the statue, aside from a tangential kind of murky role in funding the creation and erection of the statue over a century ago. UDC alleged that a predecessor had funded the monument in 1905, but the ownership records they produced were incomplete and did not show their continued ownership interest in the statue. The trial court noted that UDC did not allege that it owned the monument or that it contracted, leased, or otherwise agreed to maintain the monument in its current location on another owner's land. Instead, UDC alleged that although it lacks ownership, it had associational standing because its individual members had standing as interested people in keeping the statue where it was, and its now defunct predecessor had funded the movement. Lastly, it claimed that the dispute was highly important to the UDC's purpose. The North Carolina Supreme Court eventually affirmed the dismissal of the case, finding that without ownership rights, UDC could not claim an unlawful seizure or deprivation of their property rights, nor could they assert allegations on behalf of some predecessor organization without proof of interest or ownership or something linking the two organizations together. For these reasons, UDC lacked standing to bring the lawsuit, and the North Carolina Supreme Court affirmed the lower court decision in favor of the city. So that's an interesting case. Standing is a legal principle that lawyers have to assess every time that a case is brought, but it can get into a little bit of a civil procedure, which can be challenging.
This is a case that has to do with tax sales and takings from the Alabama Supreme Court. It's called Douglas v. Roper. The Alabama legislature has enacted a law that required property owners who had their property sold at tax sales to satisfy their tax debts before they could claim excess funds, if there were any, as a result of that sale. So this had the effect of permitting the government in many cases to keep the excess as a little something extra. Homeowners challenge this law is violating their vested rights. The Alabama Supreme Court found that property owners do have vested interest in the excess money generated from a sales tax on their property, because Alabama has a strong history of protecting individuals' property rights and of permitting residents to claim excess funds from tax sales. The court determined that the excess funds were due to the owners, and this vested right in excess funds generated from a tax sale were traced back to the earliest common law in the state. It's a really, really long opinion, but it's an interesting case. And what I found very interesting is I know that when we do tax sales in Illinois, we don't actually see very often that there are any excess funds, but that's not the case in Alabama. In several of the plaintiffs who brought this, there was a $15,000 surplus of funds that the government had been keeping prior to this case.
Okay, this is a case coming out of the Minnesota Court of Appeals versus the city of Burnsville. So in this case, it occurred in 2018, the original controversy. In 2018, the property owner sought certain approvals from the city of Burnsville in Minnesota to redevelop a residential property to a commercial use. He planned to build a car repair shop, a bakery, and an outdoor storage lot on the property. His plans with the city were approved, subject to many conditions, including that the city required he pay a park dedication fee of $37,804 in order to have his plans approved. Minnesota state statute allows municipalities to collect these park dedication fees for new developments and subdivisions, but the dedications must be reasonably determined to be necessary to the development or subdivision. The owner objected to the imposition of this fee, clearly because it was pretty substantial, and he argued that his planned business uses would not result in the need for more parkland or park services. The court in this case reviewed the Minnesota state statutes, and they determined that the language of the statute requires there be an essential nexus between the fees or dedication and the need for additional parkland or improvements. The homeowner argued that the city had no evidence that it conducted an individual assessment of this singular owner's proposed development to calculate the park dedication fee. Instead, it appeared that the city illogically applied a fee that had no relationship to the commercial use that the owner was proposing. The court agreed with the owner and found that the city had no reasonable basis to impose the park dedication fee.
So this is another case dealing with dedications or exactions. In this case, a property owner sought approval for a 3-lot land subdivision, which was located between 2 other subdivisions that had a dead-end street. So the dead-end street terminated basically right in the middle of her few lots of land, the property owner's lots of land. So the city wished to connect that dead-end street to a proposed road on the other side of the property. So they basically wanted her to dedicate a portion of her property to make the street continue through one of the lots she proposed to subdivide. But the property owner preferred that there be a shared driveway at that proposed location, and that there be no public road connection. After the property owner did not accept a condition that she dedicate and build the through street, the city denied the property owner's application for subdivision, noting that the through road had been anticipated in previous planning actions and that the city code provided as a policy matter that dead-end streets should be minimized to reduce travel burdens and for other reasons. The owner challenged this decision and it went to the appellate court. The court acknowledged that in Wisconsin, a municipality may require that the subdivider make and install any public improvements reasonably necessary, or that the subdivider provides security to ensure that the subdivider will make those improvements within a reasonable time. And Katie's case just dealt with park dedication, so many states state and local laws will allow you to pay a fee in lieu of actual dedications. But in Wisconsin, this dealt with an actual dedication of a street, portions of a property to pave a street. The property owner alleged that the city's denial was an unconstitutional taking. Ultimately, the court relied on the conditions outlined in 3 Supreme Court decisions to evaluate the property owner's takings claim. So those are the Nolan and Dolan decisions. The only reason you might remember them is because the case names rhyme, which is helpful. The court held that development conditions, the tests under these cases are used to determine whether a landowner can be required to bear costs to mitigate anticipated negative impacts of a development, such that the exaction roughly offsets the cost of development to the municipality. So it's a balancing test. There has to be an essential nexus for the purpose of the development and the exaction, and then the level of the exaction, the amount of land to be dedicated, or the cost of the in lieu fee has to make sense, which is kind of what Katie just talked about. The court held that development conditions, exactions, or impact fees must be reasonably related in their nature and extent to some specific problem or need generated by the development itself. In this case, land division did not create the need for a city dedication. So there was already the dead end street. It's not as if the owner's property development or subdivision created a dead end. And the improvement requirements were not roughly proportional with the requested division. For example, there was no increase in traffic congestion that would be foreseeable from the proposal or the approval of her request. Since there was no identified public burden created by the land division, the court held the exactions were unconstitutional and could not stand. Yes, there's a good question in the case, Megan, about your last case.
Oh, I'm sorry, I was reading at the same time. Relative to the excess tax sale case, did the Supreme Court find this unconstitutional earlier this year? I honestly don't know if they did. I wasn't aware of that, but do you know, Erin?
Yeah, there are only 2 land use oriented cases issued by the Supreme Court in their last session, and one of them was a very long, complicated case that had a lot to do with equity, which I thought was interesting, about tax sales and excess funds. So I forget what the name of the case is or what jurisdiction it came out of, but thank you so much for that note.
I know one, I had to remind myself, it was Tyler versus Hennepin County, if that was one. It had to do with,
that's the one.
Yeah. Yeah, I recall that.
And do you think that the finding out of that Tyler case then reverses the Alabama case?
No, they said that the surplus value is protected by the Fifth Amendment taking clause. So I think what the comment was saying that the procedure of counties taking the excess tax sale funds is unconstitutional.
Unconstitutional.
Yes.
Okay.
I'm not,
So
keep in mind,
it
I'm not sure if
affirms
it's
the lower,
limited at
but it
all.
affirms the case that we mentioned, I guess. So we're
Yes,
not
correct.
giving you a case that's bad. That was,
Yeah.
I think, more important. Thank you for that comment. And we made it. We're at the last slide. And we may even have time for a question. So this has to do with permitting errors. The case is ENS Realty LLC versus the Board of Appeals for the Village of Sands Point. It's a New York State case. Here, a company owned property in a residential district located in a village in New York. In 1989, the village amended its zoning code to prohibit the use of accessory structures on residential properties for habitable purposes. In other words, ADUs were outlawed in the village. In 2016, the property owner petitioned for a building permit to renovate an accessory structure, but unbeknownst to the village, the property owner planned to renovate the structure as a dwelling. After the work was complete and a lot of money spent, the village refused to issue a certificate of completion, claiming that the initial permits were issued in error. So the petitioner then sued. The court found that the denial of the property owner's application for a certificate of completion was proper because the petitioner was not using the structure lawfully. Because the structure was not a dwelling prior to the 1989 zoning code amendment, it was not a legally non-conforming use. Instead, it was blatantly in violation of the village's code. And that's our last slide. I don't.
Mag, you muted yourself.
Sorry, thank you. I said I don't see any questions in the chat. Maybe that's because we tried to answer them as we went along. I know we didn't read all of the questions out loud. Erin made a quick plug earlier to our firm's website, but I just want to mention it again if anyone missed it. We do a daily blog called Municipal Minute. If you go to ancelglink.com, you'll find on the upper right-hand corner, it mentions there's 2 blogs. One is Municipal Minute, the other is called Workplace Report. That has more to do with labor and employment. And we also do a podcast called Quorum Forum, which we think is highly entertaining. And we would love for you to listen and subscribe.
Wonderful. Thank you. I personally am tired and am ready to be done for the day. My brain hurts, and it also brings back all the feels of graduate school days with land use law and then studying for the AICP exam. So thanks for bringing back those feels. I will get, if someone could please email me your slide deck, if you don't mind, and then I'm going to post it right to our website next to the recording link. So folks will be able to have this slide deck. It's great. And actually, I'm going to suggest that folks who are studying for the AICP exam take a look at this. So thank you so much for this. We appreciate all of you. Love this strong female lady panel, and we appreciate you, APA Illinois, for bringing this session to us today. Again, remember to log those credits. This is good for your law credit, and it is also available on demand for viewing. Last day is December 31st, 2023. So register for our last 2 sessions. Head over to our website, ohioplanning.org/planningwebcast, to register for all of our upcoming sessions. Thanks to all of you, and everyone have a great weekend, and we'll talk next time.
Thanks for having us.
Thanks, Christine. Thank you for having us.
Thank you.